All right, hello and welcome. So, you're an innovator, right? Maybe an entrepreneur, or you've just got this amazing idea brewing. Well, here's something you really need to know. Understanding what you can't patent is actually just as important as knowing what you can. So, let's dive right into the really crucial exceptions in India's patent law. Just think about that brilliant idea you've been working on. Is it some game-changing software? A totally new way of doing business? Or maybe a life-saving medical procedure? Well, whether you can legally protect it, the answer might actually surprise you. Okay, so before we jump into all the things you can't do, we need to get our basics straight. To really get a grip on what isn't patentable, we first have to nail down what the law even means when it says invention and patent. So what exactly is an invention in the eyes of the law? It's not just some random idea that pops into your head. The Indian Patent Act is super specific. It's got to tick 3 boxes. 1, it has to be new, like truly new. Nobody's done it before. 2, it needs what's called an inventive step, which is a fancy way of saying it can't be obvious. And 3, it has to be useful or capable of industrial application. Bottom line, it's all about a new solution to a technical problem. And if your idea clears those 3 hurdles, the patent is the grand prize. Think of it as this incredibly powerful legal shield. It gives you a temporary monopoly, which means you can stop anyone else from making, using, or selling your invention unless you say so. It's basically the government's way of saying, hey, great job, you earned this. Right, so you've got it. Your invention is new, it's not obvious, and it's definitely useful. That means you're good to go for a patent, yeah? Well, not so fast. This is where it gets tricky, because the law has this very specific list of things that, even if they feel like an invention, are just not up for grabs. And that brings us to the real heart of the matter, Section 3 of the Patent Act. This is the section you absolutely need to know. It spells out exactly what is not considered a patentable invention in India, no matter how clever or brilliant it seems. Now, it's super important to understand why this list even exists. The whole point is to keep the fundamental building blocks of human knowledge open for everyone. Think about it. Things like discovering a law of nature, or a mathematical formula, or a new way for a surgeon to operate. These are tools that we all need to innovate. They can't be owned by just one person. And that bit about literary or artistic works brings up a really key difference. You can't patent the plot of your amazing new novel, right? That's because you'd get a copyright for it. See, patents are all about protecting how something works, its function. Copyright is for protecting creative expression, the art itself. 2 totally different tools for 2 totally different jobs. So, reading a list of rules is one thing, but how do judges and patent officers actually apply this stuff in the real world? How do they draw the line between, say, a mere business method and a real technical solution? Let's look at a couple of huge cases to see how it plays out. We're going to dig into 2 really important cases that totally shaped how we understand patent law in India today. One is about medicine, and the other is about an online business idea. They're perfect examples of where the law draws that critical line. First up, we have the huge Novartis case. This pharmaceutical company wanted a patent for a new version of a cancer drug they already had. The big question for the court was, is this new form a legitimate invention, or is it just a tiny, insignificant tweak? And this quote gets right to the heart of the Supreme Court's decision. They looked at it and said, you know what? This new form of the drug doesn't really work any better than the old one. Sure, it was a new form, but it didn't represent a real leap forward. It lacked that crucial inventive step. So what happened? The patent was denied. This was a landmark ruling because it strengthened Section 3D of the Act, which is there to prevent something called evergreening. That's where companies make tiny changes to old drugs just to extend their patents for years. The court set a really high bar, saying you've got to show a real significant improvement. Okay, now let's switch gears completely. Our second case is about a method for putting ads on a website. This put the business method exclusion to the test. Was this a patentable technical invention, or was it just a new way of doing business? And here again, the court's thinking was crystal clear. They said the core of this idea isn't some new technology. The real invention here was just the business model itself. The tech being used was all standard stuff. It wasn't solving a technical problem. And you guessed it, this was also found to be not patentable. This case really helped cement the rule that if you want to patent something that looks like a business method, it has to have a real technical invention at its core. Just using a computer to do business doesn't automatically make it patentable. So we've looked at the law, we've looked at some major court cases. What does this all mean for you, the innovator? What are the big takeaways you should be thinking about before you even dream of filing for a patent? When you step back, you can see what the law is trying to do. It's walking this really fine line. On one hand, it wants to reward truly new and useful inventions. But on the other hand, it has to protect those fundamental ideas, like scientific laws and math formulas, and keep them free for everyone to use and build on. It's a balancing act. So here's a little checklist for your own idea. Ask yourself, is this solving a real technical problem, or is it just an abstract idea? If it's software, does it do more than just run on a standard computer? Does it make the computer itself work better? And, like we saw in the Novartis case, is it a genuine leap forward, not just a tiny little hop? And all of this leads us to one last huge question. With technology moving so fast, we're talking AI, biotech, stuff we can barely even imagine. How are these legal principles going to hold up? How will a law from 1970 be applied to the inventions of tomorrow? That's the real challenge. And honestly, it's the next chapter in the story of innovation.